Does it work? Okay, good evening, everybody. If you can hear me clearly, put your hand up. Okay, that's one way of doing it there, Nuran. But the hand I'm speaking of is actually the hand icon, yeah, that you see on your screen. Yeah, you know. But that's cool. You had your camera on, so I could see you do that. So if you can, I just need to check it. Everybody can hear me clearly, so put your hand up. Let me see. Some people are not putting up their hands, so am I to take it that they can't hear me? Please keep those hands up. So, more hands, please. Please keep them up, and I can see at least if more than half of the people can hear me, then it's okay. But these people who have not put their hands up: Zipelele, Sandy, Lee, Raymond, Kim, Kenneth, Kay, Crystal, Baron, Petrus. Okay, the other hands go up. Okay. So it's possible those people can't hear me or they don't understand me. All right, for those of you who have joined for the first time, you know, these sessions, which we started basically just last Thursday for the first time for the skill preps for MRL2601. I welcome you. And for those who have been here before, you know how this works. You can turn off your mics and your cameras, and you are welcome to make a comment or to ask a question. Because we have a number of people here this evening, it's perhaps best if you raise your hand if you want to ask a question. Okay, and then we will answer questions and take comments as well. Okay, so I'm about to share my screen. You can put your hands down now. Put your hands down now, please. I'm about to share my screen with you. Let's see if that is the one I'm looking for. Yes, the recording, it is possible that the recordings can be available. The organizer will post the link possibly later on to, where you can access the recordings. All right, so can you all see my screen? We started on this past paper, this exercise that we did last week. We did a few questions here. Question 2, we did 2.1, we did 2.1.1, 2.1.2. We move on now to question number 2.2. So can everybody see that? Okay, so the board of Gangham Styles consists of Lesedi, Cello, and 2 other directors. In terms of the company's MOI, the board may appoint a managing director who will be authorized to conclude contracts on the company's behalf. No formal appointment of a managing director is made. However, Lesedi has acted as the managing director with the board's full knowledge. Okay, so Lesedi makes a purchase of grouting in the amount of 50,000. So before we even proceed with the question, further we're reading on the question, we're dealing with a private company here, and there are these 4 directors. We have an MOI that speaks of how the directors are going to be appointed. And it even says here that the board may appoint a managing director who will be authorized to conclude contracts on the company's behalf. No formal appointment is made to actually make her the managing director, although the MOI managing director may be appointed, and it's a managing director that conclude contracts on behalf of the company. However, she has been acting as a managing director, and the other directors know about it. So what subject area are we in here? What are we discussing here? In broad terms, what are we talking about here? We're talking about representation of a company. Company is a juristic entity, a corporate entity. It cannot act on its own. It needs people and individuals to represent it. And what do we call those parties? The primary representative of a company. Who are the main representatives of a company?
Directors.
Directors, okay, very good. So they are the ones, and here's a couple of questions that we must understand here. Are they the only parties that may represent a company?
Partners.
Say again.
Partners.
Partners. Did you say partners?
Yes, partners. Partners and
partners.
directors.
Okay, no, so that is where we must be very clear on our language. Okay, only the Act speaks of directors and the Act also speaks of prescribed officers. Okay, but the proper party which the law mentions is the party that represents the company is the I'm mentioning this now because this has to do with authority now. Now, who can, and representation of a company. So partners is a term that is used, it's not a term that is actually used in the Companies Act. Okay, so don't use that term partner. Okay, a partner is the term that is used when we deal with the law of partnerships. When there's a partnership agreement, and that is a completely different business model and entity and vehicle as compared to a company. All right. So the Companies Act speaks of all these officers of a company. The chief officer that actually represents the company is our directors. Okay. And you get different kinds of directors. But we're dealing here with a private company, not so. Right? How do we know we're dealing with a private company here? By usage of the words PTY Limited, Gangnam Tiles Pty Limited. So it is a private company, and as we know, private companies are privately funded. The money that is invested in the company is money that comes from private people. It doesn't invite the public to buy shares in it, and because it's a private company, there are different rules and restrictions on it as compared to a public company. Now, can shareholders represent the company? It's a different question altogether, but can shareholders represent a company? Anybody? Can a shareholder represent the company? And when we speak of representation, we're speaking of the face of the company outside of the company towards third parties when they deal with the company, right? The company's got internal relations and it also has external relations with outsiders, when it does business with other companies and other persons. So my question is, can a shareholder represent a company? We've established that directors can represent a company, but can shareholders represent a company? Okay, Catherine says no, unless a duly appointed representative or agent of the company. Correct, Catherine. Okay, if you simply a shareholder and nothing else, shareholders don't have the capacity or the ability to represent the company. It is only directors, or as she correctly points out, the duly representative parties or agents of the company. Okay, so in this example, let me just go back there. In this question, the MOI says, and the MOI, as you know, is the founding document, one of the founding documents of the company, and it contains certain formalities, certain things about the company, certain information about the company, and one can adopt a standard MOI. It belongs, it is attached to the company's, it's as an annexure to the Companies Act, and you can accept it as it is. You can accept it with additions, with the deletions or omissions, or you can even create your own set of company rules, as long as it is rules or amendments that the Act allows. Okay, the Act allows you to alter certain provisions, and there are provisions that the Act finds that or says that are unalterable. So in this case, the MOI says that it should be the managing director, but the company's been operating without a managing director. Okay, but yet the board knows about the fact that Lesedi has been acting as a managing director. Okay, so the MOI, what else can you tell me about the MOI? There's also another doctrine that comes about when a company that you need to understand about the representation of a company. When a company is formally registered, okay, there's a document that is issued by SIPC, known as a a notice of incorporation or a registration certificate confirming that you have gone through the whole process now of becoming a company, and that you've paid the fees that is required, you've appointed the directors have consented to that appointment, the MOI that you've adopted is valid, it has passed the scrutiny of the company's commission or SIPC, and you get that certificate, and that now confirms that the company has been registered. Okay, so the minute the company is registered, there's a doctrine of company law that comes about. Who knows what that doctrine is? Once you are registered as a company, there's the doctrine of publicity or disclosure that automatically applies. Okay, this is the doctrine that basically says that the company's information is public. Not all information, but information as contained in the MOI is now public. Did somebody want to ask a question there? Ruby Lee says constructive notice. Now, publicity, the doctrine of publicity and constructive notice, these are the inverse of one another, okay? Because when you deal with a company, you're dealing with a juristic entity, and all you have is a possible director or an agent that you're busy with. You don't know, or all you should know, according to the other doctrine, is which is the doctrine of constructive notice. What does that actually mean? It means that the company has already given you notice about its information, okay? So the minute you register, there's this doctrine of publicity, and when you have the documents made public, there's the other doctrine of constructive notice, that when you deal with a company, you should already know what's going on with regard to the internal workings of the company, insofar as the public documents are concerned. Okay, so constructive notice is the company giving notice without actually giving notice, physical notice. Okay, it's a type of symbolic notice that is that you as the public or the third party dealing with the company should know about. All right, so you should know, for example, in this example, that you're dealing with a private company. You should know that there are at least two directors called Lesedi and Cello, and there's another two directors. You know that the board, that the MOI states, because you can uplift that. One can uplift a copy of the MOI of a company. Once a company is registered, you're given a registration number, and you can then do a search on the records of the company's commission, and you can uplift copies of the MOI, and you can see, okay, who are the directors? Where is this company? What is the principal business? The registered address. What are its objectives? What kind of share capital does it have? The types of shares, the meetings, the directors, all the powers given to the parties are at meetings and so on. So what we do know is that this MOI has allowed or makes provision for the appointment of a managing director who will basically contract on behalf of the company. Okay, so the constructive notice, that is the doctrine that you are deemed to know. Okay, now there's been some changes about this doctrine. Before the current act came out, under the old act, this doctrine put a duty on outsiders. This is what the doctrine of constructive notice entails. It used to entail a type of duty on outsiders to take it upon themselves that they should know what's going on. Okay, with the new Companies Act, that duty has somewhat been diminished. It's no longer a solemn duty for outsiders to know absolutely everything. And it has been reduced now, that you should know what's going on only insofar as the public documents are concerned, but there's no longer a duty on you to know it. You can start to assume certain things. Okay. Then there's a third doctrine, which all goes together with the doctrine of the representation of a company. We've got the publicity doctrine, the doctrine of constructive notice. Then there's a third rule. okay, which also exists. It used to exist under the previous act, under the common law. Who knows what that rule is? Yes, you're welcome to speak. Yes. Okay. The doctrine is the Turquoise rule. Have you ever heard of it? The Turquoise rule? This is the rule. It's all related to each other. Okay. The Turquoise rule of company law says that, you know, when you're dealing with a company, right, we know now that there's the doctrine of publicity, also known as disclosure. When the company registered, there's a doctrine of constructive notice. And then there's also the Turquoise rule. And the Turquoise rule says that when you are dealing with a company, you know, and the company's documents, like the MOI or the what used to be known as the Articles of Associations, now the MOI, provides that there's you know, a certain internal requirement that must be complied with. Then when you deal with a company, you can assume that that internal rule has been complied with. Okay, that's the Turquoise rule. It says that when outsiders deal with a company, what do they know about the company? They only know the public documents. All they know is that the MOI says that the managing director is the one that is to be the one that signs contracts on behalf of the company. That's public, right? But and as to whether a managing director has actually been appointed is another question. That is an internal requirement. Okay. So the Turquoise rule says that if the company says certain things to you, for example, in this case, Lesedi has been acting in the position of managing director with the knowledge of the board, and whether they actually signed a resolution to that effect and appointed her as the managing director, you don't know that, right? Because that is something that will happen internally in the company. And when you deal with a company in such a case, then you can safely assume that that internal requirement has been complied with. Okay. Now, I know this may sound a bit complicated. Are there any questions, guys, that perhaps is everything clear about this? Is there perhaps a question you have?
Got a question, but it's not to do with the work. It's to do with the scope that we have to study, because I went through the study guide and I wrote down all the paragraphs that it says we need to refer to, and then it just showed me that like question 10, 11, chapter 10, 11, 13, and chapter 8 is not covered in the study guide. So do I still study it or not?
Okay. Can you perhaps share that scope with me? Because I have not seen the scope. So I can't exactly say. So can you tell me now, what is this? What are the chapters referred to there in the scope?
So chapter 1, only of study unit 4, only paragraph 2 needs to be studied. Then basically the whole of chapter 2 in the textbook needs to be studied. Chapter 3 in the textbook needs to be studied. Chapter 4 needs to be studied. Only certain paragraphs. Chapter 5 also according to the study guide. And then chapter 6 also certain paragraphs. Chapter 7 certain paragraphs. And then there's nothing in the study guide that pertains to chapter 8 of the textbook. So do I look at chapter 8 of the textbook, or do I leave it out because the study guide doesn't even mention one section in chapter 8? Then chapter 10 of the textbook is not mentioned at all in the study guide. And also chapter 11 is not mentioned in the study guide. Chapter 13 as well, plus chapter 14 and 15 of the textbook is not mentioned in the study guides. So what I'm asking is, do I leave these chapters out because it hasn't been included in the study guide, or do I still study them? And then,
okay, now remember, yes, go on.
And then also there's certain, the chapters that are included in the study guide, there's only certain paragraphs that have to be studied in correlation with the study guide. not the whole chapter. Only like for chapter 4, for instance, the study guide only refers to paragraph
certain
4.
paragraphs.
Yeah.
So now, okay, this is typical of UNISA, pedagogy, UNISA ways of teaching, okay? Now, UNISA has always said this, as a student, it's one of the ups, one of the advantages of actually, understanding how UNISA works, okay? So you need to very meticulously follow the instructions that was given to you in your last tutorial letter, okay? Having taught this subject, I haven't been teaching it in the last 2 years or so at UNISA, but I mean I've taught it for about 12 years at least, and pretty much the same areas of focus are repeated time and time again in the exam. Okay, so very carefully now. What they are giving you there is actually very valuable for the purposes of preparing for the exam. If they tell you ignore this chapter, you do so. In other words, don't focus on that for the exam purpose. All right. So they have given you some very valuable time-saving tips there, and by virtue of telling you that, they're telling you exactly, look, we're going to be formulating our questions on that area. Right. So broadly speaking, you know that this course is basically a study in comparison, right, between the various business vehicles that you get in South African law. You did partnerships, you did the business trust, you did you did company law, you did close corporation law. And what they've been doing for the last 20 more years is to tell you partnership and trust, business trust law is not covered in the exam. It is covered in the assessments, like the assignments. Not so?
I can leave it out, which I have.
Yes, because that was covered in your assignment. Who disagrees with me? I mean, who can show me anything different there that that the test, the assignments rather, covered partnership law and it covered business trust law? Did that not happen in your case? For those of you who did the first assignments, what we're doing now is a self-assessment exam type thing that we're doing. That comes from your tutorial letter. But this is how they've basically been testing students for many, many years, and they haven't changed that. So you don't have to study partnership law now, because they said that was covered in your assignments. And don't study business trust law. That was covered in your assignment. And for the assignment, they gave you a year mark.
So what you are essentially saying is that I only have to study what is in the study guide.
But now, if you look at what the study guide says, the study guide makes a reference to certain parts of the textbook.
Only certain parts of the textbook, yeah.
Only certain parts. So therefore, a third product arises in your material, which is you've got your textbook there, you've got your study guide. Right? The study guide guides you through the textbook.
Yeah.
So you need to look very carefully at the instructions. Sometimes the study guide goes into such detail, it may make you wonder, why did we have to buy the textbook? But on other aspects, again, it refers you to the textbook, a very important part. So you cannot actually go without the textbook. You need that textbook to be read, to be consulted when the study guide tells you to do that. So in your preparation, I mean, it's quite late in the day, guys, in the terms of the academic year, and you should have now made your notes consisting of the important things that are given to you in the study guide, as well as the material in the prescribed textbook. All right. Now, another thing you must understand is that, so you won't be tested on partnership law and trust law in the exam. The exam itself will be 70% company law and 30% close corporation law. This is clearly set out in your tutorial letters. All right. So this is how you need to approach the exam now. And that should give you an idea that, okay, after the exam, I'm supposed to get 20% for the assignments that I did, right? So I have a year mark. If I did submit both the assignments, or I don't know if it's one of the assignment that gives you your year mark. So the exam will be basically out of 80%. And in that 80% will be in the form of 100 marks. And the 100 marks are 70% focused on company law and 30% focused on close corporation law. Okay, and within that 70%, they are now even telling me they're making the scope even finer now and narrower for you to tell you, okay, in company law again, focus on things like the legal personality. You should know that is a classic that always comes in. The legal personality of a company, the separateness, piercing of the corporate veil, test for piercing the corporate veil, types of companies, how companies are incorporated, the differences you must be able to say, pre-incorporation contracts, representation of a company, which we're busy doing right now, corporate finance, shares, debentures, and distributions. You know, you must have a basic understanding of the types of shares that there are, the classes of shares, how they're different from debentures, what they mean. A lot of emphasis is on a thing known as the solvency and liquidity test, which filters in with so many other things. Okay, so shareholders and company meetings. Okay, so remember this all falls within that 70% that they're going to be examining you on. Okay, so this has kind of happened a lot over the years. Directors, you know, particularly you should know, you know, the office of director, eligibility, the disqualification of a director, the director's duties, specifically his duties of these fiduciary duties, his duties of care and skill. What can happen now in terms of the new act to a director? Okay, yes.
In our assignment,
Which one now?
Duties of the director was asked. So will it be maybe repeated?
That I cannot say. It, you know,
Okay.
because what often happens, I have no part in preparing the exam. I have not seen the exam, so I cannot say. But because they already narrowed the scope of the material for you this much, okay, that you have to cover these areas, you know, it's quite possible that it will come in again, although I cannot say with certainty that it won't, you know, that they'll repeat it again. They won't repeat it. So you must know about directors, how they are appointed, what's the fiduciary duties, the business judgment rule. What can happen for a director? You know, he can be placed under probation, he can be declared delinquent, you know, his removal process and that kind of thing. The auditors, you know, the function of a company auditor, the function of the company secretary, very important. So things that are normally not included, okay, are things like, I'm just looking at the textbook here, fundamental transactions, you know, insider trading, business rescue, those things are not normally included, okay? What they do include here is, like I said, the auditors, the audit committees, the company secretary, and lastly, but importantly, remedies, enforcement, and alternative dispute resolution with specific emphasis on the rights of minority shareholders, protection of minorities. Okay, and being able to see what the remedies, what the relief there is for minority shareholders. All right, so all that within that 70%. Okay, how are you going to figure out, you know, they're all going to be covered. That areas I mentioned will be covered. How are they going to be covered? What kinds of questions? Go through the past question papers, go through past assignment questions, go through, you know, all these things that cover the area that I've mentioned. Okay, so they will ask you the same question with a different variation. They will ask you the same question, but for less marks or for more marks. You know, so you need to kind of know the subject basically to answer it properly. Okay. Okay, so don't underestimate now the importance of the close corporation law. Okay, that's very important because that's 30%. So many people, yes, Mr. Marinus or Miss Marinus, your hands up.
Oh, yeah. I've got something that I need that I want to ask on the third one rule, but it's fine. I'll wait
Please
until
ask it.
you're done.
Oh,
No,
okay, sure.
what
We'll pick up from you there. Not a problem.
No, what because I heard what you said and you spoke about if a person is not aware. Are there exceptions to this rule? Say, for example, if the outsider was aware and still contracted, perhaps with the, I'm
Yes.
not
No,
even sure what
absolutely.
makes sense.
Yes. Yes, absolutely. That is, in fact, one of the exceptions to that third one rule. Okay, where a party who did business with the company knew that person never had authority. Right? Or now the act says reasonably should have had knowledge that the party didn't have a right to represent the company. That is the test. Okay, so the third one rule, where you can assume things internally have been sorted out with the company, you may rely upon it insofar as you are dealing fairly with this company. But if you have knowledge, hey, but this person was no longer the director, doesn't have the authority. Later on, if you sue the company and the company raises this point now that party never had the authority, then because you knew about it, and it can be shown that you knew about it, then that point can be maintained, can be held. And now let's just quickly deal with that question, the rest of that question. So what does Lesedi do now? That is now being what was discussed so far about representation. But before I go on, is everything clear now? That lady Nuran asked that question now
Yeah,
about
thank
the
you
exam.
very much.
Okay, so Rook, don't underestimate now the 30%, because that's all of those things must be covered in the 70% of the paper. But the 30%, okay, which is you must never underestimate how important it is to cover your close corporation law as well. Okay? And the whole purpose of the course is to compare all these business vehicles, right? Ideally, you should easily be able to distinguish between the advantages and the disadvantage of a company and a close corporation. And ideally, you should be able to explain also the nuances, the fine differences between a company and a close corporation. Okay, certain rules do apply for companies only, and for close corporations. Okay, and vice versa. So we go back to our question, and we see here that Lesedi now, having acted as the managing director without having been formally appointed in terms of the MOI, but with the knowledge of the board, goes ahead now and does enters into a contract on behalf of the company, and she, what does she do? Makes a purchase of grouting. Okay, it must be towel grout in the amount of 50,000 Rand from Tendai on behalf of the company. 2 months later, Tendai sues the company for the outstanding amount in respect of the grout. Okay. Gangnam Style, the company now denies that they are liable for the payment. This is a classic company law question. Now, I can tell you, from 2004, I've seen questions like this come in, either like this or with slight variations, depending on where they want to test you. Okay. So explain what requirements Tendai would have to prove to hold the company liable to the contract, despite Lesedi's lack of express authority. Okay, now the same question can be asked for 20 marks, 25 marks, but you guys are fortunate. Those days of asking questions with 20 marks for one question are over. They will ask you for a maximum of perhaps 10 marks for a question like this. But now they ask you, what must you prove now? Will the company be able to escape liability? Can the company actually raise this fact now to say, well, Lesedi doesn't have authority, therefore we're not going to pay. Our MOI says that it is only the managing director that can do such things, but she did it. So without the MOI giving her that approval, how would you guys answer this? Let us hear. But you asked to explain the requirements of what this person will have to prove to hold the company liable. What do you guys think?
I would say whether a person was aware in the first place that, or had knowledge of whatever was, wrong or not.
Yeah, okay. Because we're dealing with those doctrines we spoke of, right? Because here the Turkwan rule would apply. So you would have to mention, the effects of the Turkwan rule, which is part of the Companies Act now anyway. The Companies Act says that you can rely on someone's word when there's an internal requirement, and you can accept that that internal requirement has been complied with. Okay? What else can you prove now? You can say that there's another doctrine of law that will apply here. All that person will have to prove is to say that they created the impression that this person did have the authority to represent the company. In terms of the Turkwan rule, I can assume that was an internal requirement. All I know about that company is the MOI, and the MOI is saying that the managing director is the one that can represent the company. I don't know whether they've actually appointed her. That is something internal. That is not public. So therefore, I'm entitled to rely on it. But there's a further doctrine of law that will apply here. When someone creates the impression that they have authority, what do we call that? And you rely on that impression.
Isn't it the misrepresentation or?
No, it's one of the elements of it, but there's a different doctrine here.
Doctrine of estoppel.
Correct. Right. Estoppel. And it's basically this, what I've mentioned so far, that the doctrine of estoppel is a defense, okay? It's a defense that you have against somebody who says they don't have authority. Okay, but they have created an impression. They've made misrepresentations, as you mentioned, right? So if you create the impression that I have authority to represent somebody, I have the authority to do this, and I have the authority to do that, and you con me, you deceive me, but I believe you, okay? And I act upon what you tell me to my detriment. Then later on, you can't raise this fact that you don't have authority because of the misrepresentations that you made to me. Okay? How does it apply to this question? Lesedi, or not Lesedi, but the company created the impression through the actions of Lesedi that Lesedi was authorized, that Lesedi was in fact the managing director, even though she didn't have that proper authority. So this person, whatever his name is, Tendai, acted on that misrepresentations. Or even if it may have been done, intentionally, then it would be a misrepresentation, or it could have been done, without the intention to deceive. So then it's still incorrect. But still, the representation made was so that this person was misled by it or acted upon it and suffered prejudice now in that the company doesn't now want to pay him. So when this company sued, or when he sued the company and this company raises the plea that, that the agreement is invalid because Lesedi doesn't have the authority in terms of the MOI, then this person, Tendai, can what we call can replicate in terms of civil procedure, and raise this defense and say, no, you can't say that anymore because you are stopped from raising the truth The truth is you don't have the authority, yes, in terms of the MOI, but you created the impression that you did. And because you did that, you are now stopped from raising the truth, which is that you don't have authority. It's a mouthful, but tell me now, guys, now's the time to ask for explanations if it's unclear.
So, can the third party then use the protection maybe of the Tankwa rule in order, as you know, if one raises the doctrine of estoppel, can the other party then raise the Tankwa rule as a defense?
No, the Turkwan rule favors the outsider, right? The constructive notice doctrine was basically like, that was the old duty that you as the outsider should know what's going on with the company because the company's documents are public, right? The Turkwan rule makes it easier for outsiders and says, well, you can assume that if there's an internal requirement that the company must fulfill, and in this case, there was an internal requirement. The internal requirement was that the managing director must be the one to sign contracts on behalf of the company, right? The representation made was that Lesedi is the managing director. This requirement internally, whether the formality was complied with, you as the outsider don't know that because that is an internal thing within the company. Right. So the Turkwan rule allows you to rely on you deal with a company that, hey, I'm not going to ask them show me the resolution to confirm that Lesedi has been appointed as the managing director. I can safely assume that the company is complied with that requirement, right? And I can only not rely on that if I expressly knew that. If I expressly knew that the person didn't have the authority, then I won't be able to rely on the Turkwan rule. All right. But even so, estoppel applies in this case because of the misrepresentations or representations, depending how you look at it, that were made, the impression that was created, that the person was in fact the managing director when they were not. Who do we contact when we want a session on a specific area or areas that we could be struggling with? Things that we could come across perhaps over the weekend and we want to address it before the exam. Well, Sandy Lee, that would be me. I've been saying that many times already. You can contact me. There will also be a link, and you can set up a one-on-one session. You email me with a request and the area that you want me to deal with, that you're struggling with, and then I will set up a session for you, and then we can talk about that. Is that clear, Sandy Lee? Here's my email address also. There's also a link up there that I think Adele might have posted here, and that is how you can take it from there. Okay, it's a service that is being offered by the university. So for 5 marks, that's your challenge, guys. 5 marks. Like I said, the same question can be asked for 25 marks, but you must now be able to distill the principles and the legal principles and formulate it in such a way that it's at least 5 marks. And yet deals with all the issues. Okay, everybody clear? Can we move on to the next question then? See, this is the purpose of these exercises, that I will answer these questions, but then we always discuss the relevant subject area in which it falls. Next question. Figozo Limited showed an increase in profits for the 2018 financial year. At a board meeting, the directors decide that dividends should be paid out to the company's shareholders. Indicate what requirements in terms of the Companies Act 2008 must be adhered to before the dividends may be declared and paid to the shareholders. 5 marks. Again, I say it again. It could even be asked for double that amount of marks, but now you must distill and decide like exactly what are the important points that must be raised here. So with every question, a problem type question in company law or in entrepreneurial law or commercial law, where we deal with a subject like this, we break it up, guys. So what type of company are we dealing with here? Let's start if it goes or limited. Let me give you my comments on it and it can help you answer.
Public.
So, a public company, right? In contradistinction, that is clearly distinct as compared to a private company. So here, this is a different kind of companies. There's different restrictions and different compliance issues that will apply to it. A public company is a company that in part or in total gets its funding from the public. It invites the public to buy shares in it. And because of that fact, it has got certain other reporting requirements, disclosure requirements that the Act requires it to make. Right? It must disclose its financials, make it public every quarter. Okay, it needs to give a statement, which we call a prospectus, in which it will, declare and give you background about the company, because you're going to be buying shares as members of the public in this company. So you must give details about the directors, the prescribed officers, the auditors, give information about that. Okay, you need to show that you're like a good corporate citizen. And here we delve into corporate governance, which is a different little, part of, but yet, it's not the focus of this course. This course deals with pure company law, but corporate governance is how, you should conduct the company now, especially public companies and public listed companies. Okay, so it showed profits now for the financial year end. Okay, now you must break this further now. How do you understand what is a profit? How do we decide profits of a company? Not only of a company, but even a sole proprietorship, even a partnership, even a close corporation is a formula to determine profits. What is the formula? Where do profits come from?
Assets? No, not assets.
No, assets, not assets. No, not assets. See, this is an accounting sort of formulation. So those of you with an accounting background will be, will be seeing, oh, what is he trying to say? It's such a simple thing. How do you determine your profits? Income less expenses, sales less cost of sales, right? Right. That's an important thing, because your profits, when you invest money into a company, is the guarantee that the company will turn over a profit. When you start a business tomorrow, whether that is a company or a sole proprietorship or a partnership, whatever it is there a guarantee that you will definitely be making a profit there? There's no such guarantee. Right? There's no such guarantee. So that is one thing you must take into account. So profits must be distinguished from income. And the company makes money. It's the money that is coming in. And it obviously has to pay its expenses. And if there's anything left, that is what we could call our gross profit, right? So for this particular financial year, a profit was indicated, and at the board meeting, right? This is a board meeting now of a public company. The directors decide that dividends should be paid out to the company's shareholders. Okay. Dividends is basically the profit margin. So they must be paid out. That decision has been made. Now remember, you can't pay profits as to be determined after you calculate your income and your expenses. The difference between the two. So there's requirements before you do that. Before you decide to declare both a profit and whether it should be paid. So the question is, what must be adhered to before dividends may be declared and also to be paid to shareholders. Something I've mentioned already, and you guys should have an idea also.
Doesn't the MOU or the MOI determines how much profits must get paid or should be paid, or shares?
Not always. Remember, because shares, when you invest, when you pay money to the company, right? When when you acquired shares in the public company, what did you have to do to acquire those shares? Was it given to you for free?
Because you must invest, isn't it? You must invest.
Yes, you had to invest. That's a public company. Chances are you're not going to be the only investor. It's like practically impossible, almost. Well, I mean, not impossible. I mean, but yeah, it's highly improbable that there will be other investors as well, right? So you, as the shareholder, you've invested the money. That's the share capital, and in exchange, you get a certain number of shares. So you become the shareholder. Now, what is the classic position of a shareholder? He gave the money, or she gave the money, or it gave the money. It invested the money, it got shares. What does that shareholding entitle that shareholder to? There are four things, four rights, you could say, that a shareholder acquires when it invested share capital. What are those four
The right
rights?
to vote.
Right.
You can
That's
vote
correct.
in the.
But now put that down at number. Put that down at number. Number 2 or number 3. Let's do work in order here. Why did you invest the money? What do you want?
A profit.
Right. So the right to dividends, right? Okay. Then you can mention the right to vote. Right? Third right.
The right to have more information on the company.
Information, certain information that this is your right as a shareholder, right? To certain information, right? Because normally as the shareholder, if you're only a shareholder and not a director or particular type of prescribed officer, you are not entitled to certain, not all the information, right? You're entitled to the information for you to determine how the company is doing financially, right? Or if you feel your rights are being infringed as the shareholder, then you may ask certain information. So that's the right there, the right to information. And what's the fourth right?
Don't you ever say when it comes to if a company becomes insolvent as to.
Right. There you go. There you go. So when the company goes insolvent, when it is liquidated, then you also have the right to the assets of the company when it is liquidated. But that is a half-true statement. Do you think if the company is liquidated that the shareholders will be the only persons that want money from the company?
No, even the creditors.
Right. So you are then ranked as a concurrent creditor. Okay. In other words, you're like an ordinary creditor. You're going to have to take a number now. There are other people, other creditors, like secured creditors, like banks with mortgage bonds and landlords with rights for rental, right? And they may rank higher. So that falls under the law of insolvency. But that is the fourth right, that you still have a chance to the right of the assets of the company, okay, when it liquidates. So that is the rights of what we call an ordinary shareholder. That is where the basic idea of a shareholder comes in. So, and what grounds are you now entitled? So each of these rights, the right to dividends, the right to vote, the right to information, and the right to the assets on liquidation, can be varied to some extent that the Act allows. Okay? Now, the right to profit, I asked you that question. Does it mean when you invest in a company that you are going to get a guaranteed profit? Not necessarily, no, right? It's not guaranteed. It all depends on how the company performs. Or you may even say that one of the conditions the company may have is that, look, even though we may make a profit in our first financial year, that you hereby agree that we are not going to use this, make a distribution, that we are going to use the surplus back into the company so that the company can expand, as an example, right? So it could be deferred. Okay, so you could be the ordinary creditor, the right to profit can be changed. Okay, you get ordinary shareholders, you get preference shareholders. Preference they may be given when it comes to shareholding. Okay, they may have a different agreement when it comes to that right of dividends. They may say, look, we will not want to wait. We want a fixed return on our share. We will invest, but we don't want ordinary shares. We want to be preference shareholders, and this is now the difference between an ordinary and preference shareholder. This is the first types. The ordinary shareholder basically gets his return when the company makes a profit, or he could come to some agreement about when they will be paid, but he's going to be paid in proportion to the shareholding that he has given, the amount of shares that he has. Right? So if he's a majority shareholder, which he acquired by virtue of the sum of his capital that he put in, he gave the most capital, and therefore he gets more shares, and therefore he gets more profit because of the ratio of that. But the preference shareholder is saying, I can't wait like that. I would want to take a fixed profit, okay, but a guaranteed profit. And this is what we call a preference shareholder. According to the Act says that such a shareholder can agree to a fixed percentage of profit or income, depending, and he will be guaranteed a payment. But if the company should declare a profit, a dividend, then he will not be paid in proportion to the value of his shares. He will only get that fixed sum. If he agrees to 10% or 15%, whatever the case may be, then that is a fixed sum. But he will not get the profit in accordance with the ratio of the capital that is invested. Okay, that is the classic difference. So shares can be changed based on that. Okay, preference shareholders, deferred shareholders, okay, shareholders that have put it off to receive a dividend, cumulative preference shareholders, they've allowed things to accumulate and only then will they. There's various ways and variations of that. So the MOI can, but to a point, remember the MOI can only be altered and agreed upon, and changed to the extent that the Act allows, what we call alterable provisions, and there's certain things that it cannot do. But our question was, let's go back to our question, that what must now happen now? Okay, that we are assuming now that they've actually declared a profit, but even so, you can get a bad director that where there is no profit the company didn't make a profit in terms of accounting terms, right? Can you pay the profits out of income of the company? Is that allowed? You see, a warrant you've put here, the board must authorize the distribution. That's partly true, right? It is true, but now it's not going to be enough for you to get the marks now. You may get like one mark, but you're not going to get all the marks. You now need to specify. Okay, in fact, this is now an assurance now. Okay, under old company law, let me not go too far back, but the current Act simply says that the board must authorize it, and they must authorize it after certain things. They must pass a resolution, basically. And what must that resolution say? The resolution must say that, okay, we've declared a dividend, number one. Number two, that if we pay out the dividend, and after paying out the dividend, that the company will pass the insolvency and the liquidity test. That is very important. right? It will pass the insolvency and liquidity test. In other words, that even when we make this distribution now remember, I've explained to you now what profit means. Profit means that the income has been there, and the income was used to pay the expenses, and there's still something left. And from there, we declare the dividend. That is the proper way. But sometimes people may be paying dividends out of income, which is not right. So who's going to be responsible for that? And this is where the New Companies Act says that when you make a distribution, there must be a declaration that indeed the company is in a correct financial position to do it. And if it pays out, it will pass the liquidity test and the insolvency test. The insolvency test says that who knows what those tests mean, basically? Who knows what those tests mean? The insolvency and the liquidity test. It is coming up over and over.
I think solvency, I think the assets of the company must exceed its liabilities.
Yes, right. Now remember, that is the test for insolvency, right? That when we make this distribution now, we're going to pay the shareholders' profits, but even when we do that, then our liabilities won't exceed our assets fairly valued, right? And that's the insolvency test. What's the liquidity test?
Doesn't the liquidity test look at future expenses?
But that is not what the wording of the Act is used. The Act uses very specific. Yes.
Or reasonable foreseeable financial circumstances or situation of the company.
No, basically what it says is the liquidity test. You know what liquidity means? Liquid means that you got enough cash on hand. And we're going to pay out the shareholders dividends, but now we're bankrupt when we do that. Imagine you do that. Who's responsible? So this is what the Act is saying. The Act is putting this responsibility on the directors, that they must pass that resolution, which is a resolution you must be careful as a director of a company to pass. Because what you're basically saying is you're giving an assurance. We will still be okay. We won't be bankrupt when we pay them out. We'll pass the insolvency and the liquidity test. The liquidity test means that we are able still to pay our ordinary debts for at least 6 to 12 months afterwards. Okay, that is the liquidity test. That the company, after it has made a distribution, after it has paid out the shareholders their profit, that it will still be able to pay its debts in the ordinary course for a period of at least 6 months or 12 months. Okay, so now this method, guys, is something that the new Act has brought in. And I say new Act, I mean this Act it's 2008, but it only came into effect around about late 2011. Okay, late 2011 when it came into effect, it was properly promulgated. This test and of everything is put on the director's shoulders. So if the director passes a resolution that we paid out the people, the shareholders, and later on it comes about that the company was actually bankrupt. They couldn't do that. They couldn't pass the liquidity and the insolvency test. What happens now?
I think if it doesn't pass the test, then no one is entitled to dividends or something.
No, but let's say they paid it out. So now what? Another company fails the test afterwards. So majority resolution is required, of course, on terms of directors to agree to such a thing. But it now means that those directors could be held who signed it while it was untrue, who passed the resolution while it was not true. They will be personally, or they could be personally, liable now for any damages that are suffered by the company. Okay. Any further questions? No. Okay, so we move on.
Are you allowed to
borrow
from the? Are you allowed, as a shareholder, as an ordinary shareholder, to borrow from the company?
You see, again, that's not normally. It is possible in theory, the company can make loans to employees and to buy shares even in it, but the same thing will apply. What is it? A resolution by the majority to confirm that if they were to do this, if they were to dispose of their own assets or make loans, that the company will pass the liquidity and the insolvency test. So every time it comes back to the directors. This was a bit difficult to do in the previous act. The new act makes it a lot easier to see who's going to be liable when there's reckless behavior by directors, when they say things that aren't true. And, to be able to sign such a resolution, just let's take a moment quickly. As a director of a company, when you say, look, what will make you able to sign such a resolution? You must be quite convinced that, look, if we pay out this money, borrow this money, buy this thing, or pay out the dividends, that our assets will still exceed our liabilities. So you must be able to satisfy yourself. That's your responsibility, right? And you must also satisfy yourself from evidence that of the company's workings that we will still be able to pay our debts. If we pay this money out now, it means we're going to have a cash flow. We can't pay the rent the next month, or we can't pay salaries the following month, right? So you will be personally liable as the director if you lie about that. And the Companies Act also says that a director who is, when such a resolution is placed on an agenda at a meeting of the board, and they must consider this resolution, that you cannot, as a director, if you believe it to be true, you sign it. But if you don't believe it to be true, you cannot not vote. In other words, you cannot abstain. Okay? You have to vote against such a resolution. Failing to vote is also an act of negligence. You can be put under probation or possible delinquency for failing to do that. Okay? In fact, when you do it, knowing it's untrue, that is in fact how serious it becomes for you as a director. Okay? So if you are unsure, if it hasn't been, demonstrated to you that the company will pass the liquidity and the insolvency test after making a distribution for whatever reason, then it is in your best interest rather to vote against such a resolution. Okay, guys, it was 5 marks, but I kind of overkilled on it, but for your benefit, so that you could see how far it reaches. But at the 5 marks, I've covered that, and now it's for you now to be able to formulate it into 5 marks. Okay, 2.4, Phineas. Phineas was recently appointed as director of, is it Purity Paints Pty Limited, okay? A company that produces and sells paint. All right, Phineas approved the purchase of 10,000 liters of a base paint that cannot mix with the paint coloring that the company sells. In the result, the company has to destroy the unmixed paint and consequently suffers a financial loss of more than 5 million rand. The company wants to claim the damages from Phineas, as it is widely known in the paint industry that this base paint is only used for very specific purposes. Advise the company how the court will determine whether Phineas has breached his duty to act with reasonable care and diligence. Okay, so now it's again, we're dealing with directors, and one of the duties of directors, okay, this is one speaking or one type of duty that the director has. What is the other major duty of the director?
Maybe he mustn't abuse his position as director.
No. That is like sort of one of the. You see, what you guys must understand here is the directors have primarily 2 types of duties. They mentioned it, the one in the question here. The other major area, within that area, that's what I'm asking. You're giving an example of it, but it's broadly called something. What is that?
It's not a fiduciary duty. No.
Say again?
Fiduciary duty.
Yes, that's it. That's the fiduciary duty. Okay, so this is how you must understand where it all fits in. Otherwise, later on, it could become quite confusing, man. That is why I'm trying to place you in the area so that you can understand and put it into context. Directors of companies, once you become a director, there's certain things that attach to you. You know, there's many things, but primarily you have your fiduciary duties and your duties of care and skill. Okay, now we're not going to go into the director's fiduciary duties now because we're not asked about that. It has to do with his duty of the trust that is placed on him and how he must respect that office and not abuse it, you know, and avoid conflicts. But this has to deal with a different thing now. This is the duty of care and skill, because under a common law, anybody can almost be sued for certain acts of negligence. Not so. Right. If you go to a doctor and the doctor performs, you know, your dentist, let's say you go to the dentist and, you know, you want to have filling done or you want to teeth removed, and he injects you with an anesthetic drug, but he injects the anesthetic drug into the incorrect vein in your body, resulting in permanent disfigurement of your jaw. Okay, can we hold that dentist liable for that? Yes, we can. Under common law, that is, we don't expect dentists. We expect a certain reasonable standard of care and of you know, of work and performance of a dentist, and that he could be held professionally liable, right, for that. Now, a director of a company, there's certain standards that the director is required to uphold in terms of his of how he conducts the business of the company. Okay, so what he did here is they're simply asking us, can we hold him liable now for what he did? And there's another test that we apply. Can we hold him liable? Can we hold Phineas liable?
Yes, we can.
Can. On what grounds?
Because a reasonable director would not have done what he did. That would be my argument.
Long and short of it, you're quite right, eh? But now for 5 marks, you're going to have to add some meat onto that. Okay? You're quite right. If we compare what is the standard of care required of a director in terms of the Companies Act. Now, the Companies Act has come up with what we call the business judgment test, Section 76 of the Companies Act. Okay? It says that, of course, the director, we require certain standards, but the director can also protect himself. So there's a certain amount of prudence that's required of you know, you're quite right. If we objectively look at this kind of behavior, where a director has bought something which is known in the industry as not useful and has now resulted in a loss. One, if we look at that, on the face of it, it shows it's negligent. Okay. But a director can basically escape certain things because the director is there must also take certain risks, right? He's a business person. He must take the company to places where it can make profit and to expand it. So a director can protect his actions when he's charged if he can show that whatever steps he took, okay, he took it in an informed way, that he relied on the expertise of other people in the industry, right? Or if it was depending on the type of matter he dealt with, and he should have relied on the opinions of other people who are experts in that area. Okay, so in that way he can protect himself. But in this example, he failed to do that. Okay, he didn't take any reasonable, diligent steps to become informed about this. Okay, that that is basically the thing. He didn't take any steps to find out whether this purchase is something that's in the interest of the company. And it's not a decision that a reasonable business person would have taken. But if it is, and the company suffered a loss, what I'm trying to show you here is that if he had done this after he had consulted people, experts in the field, of that particular issue, then he could have escaped the action that could be now he could be facing.
So what happens if, and I don't want to use the country as an example. So what happens if it proves that the company belonged to his wife or cousin or a niece or family member? Can he escape liability as well?
I'm sorry, repeat that again, man. Sorry, just repeat that.
No, what if it gets proven at the end of the day, even though he did not, he always say he took reasonable steps, but on the other hand, the business which the company contracted or had a contract with is a family member of his?
Oh no, that makes it worse. The thing is, in anything, remember, it ties in with these fiduciary duties. Now, the fiduciary duties, remember, it's a different duty to this. This is how you behave in terms of the reasonableness of your business acumen, your business judgment. The fiduciary duties is your duty of trust, where you must always act in the best interest of the company, for the benefit of the company, and you must avoid a conflict of interest between yourself and the company's interest, right? So that is the first thing you must show, that he had no material interest in it as well. If there is such a case, then he would have been in violation not only of the duty of care and skill, but also in violation of his fiduciary duties. Okay? So if he can show, look, part of trying to get away under the business judgment rule is to escape liability under the business judgment test, is to show that, look, I took all steps, I don't have any interest in that matter, but if he does have an interest in the matter, then it's also, it makes it one step more harder for him to escape liability under the business judgment test, the negligence test. Yes, are there any questions? Khadija.
Yes, sir. What about the indemnity insurance that the company would have taken?
Exactly.
If the director.
Good point. Yes. Now that was going to be my next point I was going to raise. That obviously now, not only in companies, but it just makes good business sense that you will insure the actions of the director, right? The company should do it, and there is such an insurance available, where you can insure the company for losses against the negligence of a director. So one way to counter that, Khadija, is to ensure that the company has, liability insurance, and in this way, the company can protect itself for, against the actions of a negligent director. Okay, now this is can sometimes be tricky because, if you're going to take out a policy for that, the premiums you'll be paying are quite high, number one, and your insurer, the company that's will insure you, is prepared to insure you under those circumstances, would be very careful to formulate, look at the act and also look at, what it's prepared to cover. You must bear in mind also that you can, protect yourself against negligence, but you cannot, with insurance, but you can't have things in your MOI, or neither will you find an insurer that will cover things such as, the cases where a director will be indemnified when he violates his fiduciary duties. Okay? Because remember, the fiduciary duties is the trust position and it's a very broad area that is covered under that, where the director must never use his position to benefit himself, and you can't have anything in the MOI that indemnifies the director for violation of his fiduciary duties. It is quite conceivable and quite possible, however, to cover the director for his mistakes, for his reasonable mistakes only. Okay? And that is how we, in modern commerce, we many times they mitigate these losses by taking out policies to that effect. It's a good question. All right.
Okay.
Okay, let me just see now. We've got like 5 minutes left. Let me try and get the true and false. You guys can always find that out. Is there any further, discussion questions here? Okay. Can you see the screen?
Yes.
Okay. Okay, good. So this is another course. This is CLA 2601. This is pretty similar to your course. I mean, this is a BCom law degree, company law question paper or course. It's called Commercial Law 2, and it is pretty much similar to your course. Okay, it's just 1 or 2 areas they don't cover, and also they don't require you to go into depth about case law discussion. Prescribed cases. But I wanted to cover at least something on close corporation law here. Let's look at question 4. Stephen is a member of a close corporation. Because remember, as we're discussing this, as it relates to companies, you should also, really at the back of your mind, see how does a close corporation compare to this? That is the whole purpose of the course. So Stephen is a member of a CC. As a member of a CC, he owes 2 duties to the close corporation, namely a fiduciary duty and a duty of care and skill. Explain to Stephen what the fiduciary duty entails. Okay. So the question here is, what does the fiduciary duties of the members of a close corporation entail? Who can tell me? Who would like to venture there? What are the fiduciary duties of a member of a close corporation? Yes?
That, I don't know. Maybe they must also act in good faith.
It's the same fiduciary duties. Yeah. Look, it's the same fiduciary duties. As you should have known, if you compare, you did partnership law. Do the partners in the partnership also have duties or fiduciary duties? They do, under common law. All right. When you enter into a partnership, which is a completely different vehicle, completely different type of business entity compared to a company and a close corporation, partnership doesn't have separate juristic personality, but it does say that when the partners enter into a partnership agreement, they've got certain duties, to each other, that they will always act in the best interest of the partnership and for the benefit of the partnership, and will not compete with the partnership, not make secret profits, with these other partners. So the close corporation is sort of the type of business entity that has got the best of company law, of a company, and the best of a partnership. It contains those elements. If you look how it developed, basically, it only developed in the 80s as a way to offer small businesses an easy way to start a corporate entity, have separate juristic personality, and be easy to run. To start a company, you need share capital, and share capital must be cash. It has to be in the form of share capital money. To start a partnership, you don't have to only contribute money. You can contribute anything of financial value. And this is where the closed corporation has something similar. Okay? The contributions that you make as members can be either in the form of cash or anything of commercial value. So the common line thing here is that they have the fiduciary duties. So the fiduciary duties are, it comes from the common law, which is that you must act in the best interest of the closed corporation. You must act in the best interest of the closed corporation for the benefit of the closed corporation, and you must avoid a conflict of interest. Okay, and in reality, it means pretty much the same of what the duties that a director has to the company is what the members of a CC have, both to the CC and to the other members. Okay, which is from case law, we can see it is, never to use that position, for example, to make secret profits. It extends quite far. Even the information that you get, you must not use. Okay, where you have an interest, you have a duty to disclose that interest to the company, just like with members of a CC. If there's a position or situation that arises in which a conflict may arise, you are duty bound to disclose that. Okay, guys, that's our time. I've given you my email address, and you can also click on the link that Adele has put in the in the chat box to set up a session. How you can do that is, first, if you have difficulty, jot that down, that particular area, and that I will discuss with you in the one-on-one session. It can't be too broad a request. Like, I don't understand company law, that I won't be able to assist you with, right? You would have to tell me. I have difficulty having understanding pre-incorporation contracts. I have difficulty understanding, the difference between a shareholder and a debenture holder. Then we can have a session about that. So if you can list your difficulties and you need me to assist you on that, that's what I can do. All right. So good luck. When are you writing? Is it next week? What, next week Friday or next week? When are you writing? The 30th, eh? 26th. Oh boy. I don't know if we will have another class on the day. Yeah, so I don't know. So this could very well be our last formal session like this, guys. But you can still, of course, get the one-on-ones if you contact me. Then I can see Dallas asked you guys for feedback in that feedback form over there. And I'm sure she's going to ask me to ask you, and I'm doing it now. That please, you guys, we'd appreciate your feedback so we can, improve the service to you, the students. Everything of the best. So for those who will want to contact me, you can do that. Thank you, and good evening.
Thank you.
Okay.